Right, step 4 in the Metropolitan Police Dirty Tactics. Their solicitors will make legal threats of seeking costs if the claimant does not comply and ask for more time to investigate the matter, normally 3 months. Let's refer back to the 27th of May 2014. M.H. Wood reopened the alleged Tiffany & Co. CRIS crime file and made additional entries, then closed this file, a file that had not been opened since 27th of June 2013. Commentary: the beauty of the CRIS crime report login system. 1. The person needs to log in to use the system, and it makes a reference to the person's name, the time, the date logged in, and the time logged out. 2. It makes a note of what was entered, but this information is changeable anytime. It acts like an electronic filing system for monitoring crime incident. There does not need to be an actual crime, just the incident of crime that may or may not need to be followed up. In a letter dated 18th of February 2015, the Metropolitan Police's solicitor, Clyde & Co., contended that our client is investigating the allegation within the letter of the 9th February 2015. They further contended that they will respond to my pre-action letter in full within 3 months. In a letter dated 27th of February 2015, I agreed to the 3 months request and contended that their investigation must be completed by the 19th of May 2015. Otherwise, court proceedings will follow without further notice. Step 5 in the Metropolitan Police Dirty Tactics. Don't reply after the request for more time to investigate, and employ the wait-and-see tactics to see what the claimant does. In the meantime, the Met will go to Step 6 of their dirty tactics. Step 6 in the Metropolitan Police Dirty Tactics. Start printing out evidence to support the defense. In evidence supplied to me during the course of the court proceedings, it appears that the Metropolitan Police was busy investigating my allegations against them by manufacturing evidence for their defense. On the 18th of June 2015, the Metropolitan Police printed out a CRIS crime report showing connections between images 113696, 113698, and 113699 in connection with a deception theft at Tiffany & Co. on the 24th of December 2012 at 2:45 p.m. Let's remind ourselves of the outcome letter dated the 10th of October 2014 from Detective Sergeant Brendan Gibbs. He contended that, during my investigation, I accepted that you have no part in the offense and have ensured your image has been removed from the list. Step 7 in the Metropolitan Police Dirty Tactics. Sit on this information and wait for the next move from the claimant. After their actions, on the 18th of June 2015, printing out a CRS crime report making connections between the 3 images in a deception theft, there were no further reply from the Metropolitan Police's solicitor and or the Metropolitan Police. On the 1st of December 2015, without further warning, I issued the claim at the Royal Court of Justice at the Central London County Court. Step 8 in the Metropolitan Police Dirty Tactics. Start to create false CCTV footage to support the defense. On the 5th of May 2016, I received 2 CD discs from the Metropolitan Police's solicitor, which was evidence they supplied for their defense in the first interim hearing on the 17th of May 2016. One of the discs had only CCTV footage from the alleged camera 28. The other disc had CCTV footage from the same alleged camera 28, along with still images of 3 alleged suspects from the said Tiffany & Co. store. This one was marked Cam 28 CCTV footage only. When you examine the identification properties, it showed that the disc and the information on it was created, modified, and accessed on the 2nd of November 2015 time 16:28 and 58 seconds. In other words, the disc was burnt directly from source material at that time and date. This too was marked BA-1. When you examine the identification property of the same CCTV footage, it appears that BA-1 had been created on the 24th of December 2012, time 18:03 and 32 seconds. The only possible explanation to the identification properties of exhibit BA-1 being different to the identification properties of this one with the same CCTV footage, BA-1 was first saved on a clock computer with the date 24/12/2012. The alleged witness statement of the security supervisor, Bash Ali, only confirmed one CD handed to the police on the 10th of January 2013. The police made a request for CCTV footage and this CD was marked as Exhibit BA-1. Quoting from the CRIS crime report, page 22 of 34, in regards to CCTV being burnt to disk. The CCTV has been viewed by officers attending the scene, but at head office had to burn it to disk, and they were closed at the time of reporting. Staff have ordered the CCTV, which will be delivered to the store on Thursday 27/Friday 28 December 2012. The above statement from the alleged CRIS crime report would suggest that the images and the CCTV footage cannot possibly have the image properties dated 24th of December 2012. I submit that the person responsible for creating the CCTV footage and the manipulated images of 113699 forgot the story about the date these images should have had when he or she was burning these images to disk. Step 9 in the Metropolitan Police Dirty Tactics. Print out more evidence to support defense. On the 5th of January 2016, the Metropolitan Police started to manufacture more evidence. At about 12:14 p.m., A. Watts, DPS, printed out a single incident report pertaining to alleged crime from Tiffany & Co. The caller, allegedly B. Ali, the security supervisor of Tiffany & Co. The date, 24th December 2012, time 16:08. This printout showed Mr. B. Ali describing 3 alleged suspects in a deceptive theft. Let's remind ourselves again of the outcome letter from Detective Sergeant Brendan Gibbs, dated 10th of October 2014. During my investigation, I accepted that you had no part in the offense and have ensured your image has been removed from the list. Step 10 in the Metropolitan Police Dirty Tactics. Get the solicitor to reinforce the cost element and urge the claimant to discontinue the claim. On the 6th of February 2016, I received a copy of the Metropolitan Police defense, along with a letter from their legal representative, who contended that my claim had no prospects of success, and if it is struck out or unsuccessful at trial, they will seek an order to pay their costs associated with this action. They also asserted that we strongly encourage you to discontinue the claim. On the 22nd of February 2016, I filed an application notice to strike out the defense on the grounds that the defense is an abuse of the court's process, in which it defies factual or logical credibility. In a letter on the 26th of February 2016, the Metropolitan Police legal representative Clyde & Co. wrote, "We note that you have failed to discontinue your claim and instead issued an application for strikeout of the defense. For the avoidance of doubt, your application is entirely misguided, and we do not consider that it has any merit whatsoever. We shall now proceed to make an application for strikeout and summary judgment, and seek our entire cost of this action." On the 3rd of March 2016, I sent a recorded letter to the Metropolitan Police Director of Legal Service at New Scotland Yard. In this letter, I contended that this letter is to familiarize the defendant with the appearance of the claimant, so you can take the opportunity to match image number 113699 with the claimant's image. Enclosed is a recent A4 size color photograph of the claimant wearing the same jacket, shirt, and carrying the same bag as shown in the said Most Wanted poster. Step 11 in the Metropolitan Police Dirty Tactics. Use legal tools to try and sabotage the claim. Apply the notice to admit facts which are in issue. In a letter on the 22nd of March 2016, the Metropolitan Police legal representative thanked me for my letter on the 3rd of March 2016, and then attempted to try a deceptive move by asking me to sign a notice to admit facts that I was not at Tiffany & Co. on the 24th of December 2012 at 2:45 p.m. I quote from this letter, "Our understanding of your claim is that you have not been to Tiffany & Co., the store at 25 Old Bond Street, and in any event you were not at the store or even in the vicinity of the store on the 24th of December 2012. So that we may fully consider the merits of your claim and in order to assist the court further, we would be grateful if you can confirm this. For the avoidance of doubt, we enclose a notice to admit facts to this effect." The only problem with the above is, if I sign the notice to admit the above facts, the association between my image 113699 and a connection to Tiffany & Co. would be out of my grasp for the rest of the proceedings. Very smart move, like checkmate in one. My response to the notice to admit facts in a letter on the 23rd of March 2016 to the defendant's legal representative, I contended that it was hoped that the defendant would use the opportunity to compare my image with the Most Wanted image, 113699, and reassess his position on the facts in issue, but instead he has used the opportunity to abuse the process by issuing a notice to admit facts, which is at the center of the dispute. Enclosed also a signed copy of the notice to admit facts. You will notice what I think of such requests by crossing out of the admission of facts and the notes inserted, which is then signed and dated. In a letter on the 6th of May 2016, the Metropolitan Police legal representative Clyde & Co. sent me a copy of the application notice filed with the court. They made a request to the court asking for their application to be heard at the same time as mine on the 17th of May 2016. The defendant's bundle of evidence for the hearing dated 17th of May 2016. In the same envelope, they included witness statement which supported their false defense, false and falsified documents, falsified CRIS crime report, tampered witness statement from Tiffany & Co. with extra information added, tampered vital free job sheet with extra information added in regards to the alleged suspect free, recreation of CCTV footage in a small room which supposed to be in a private sales area on the ground floor of Tiffany & Co., manipulated images of 113699 on the alleged exhibit BA-1 CD disc, and new composition of the Met Most Wanted poster, which is totally different from the original poster,